Melbourne town where the suits all grind, there's a lawyer with a vision, one of a kind. He's the Aussie Overlaw'd, he'll fight for your rights, and he's got his own channel shining bright. From the courtroom to the web, he's got it all, sharing legal knowledge, answering the call. He breaks it down in a language we all understand. The Aussie Overlaw'd taking a stand. With his Aussie charm and his legal know-how, he's a hero we need, showing us how. He fights for justice, no case too tough. The Aussie Overlaw'd, he's more than enough. He's more than enough. In Melbourne town where the suits all grind, there's a lawyer with a vision, one of a kind. He's the Aussie Overlaw'd.
And good afternoon, good evening, and good night, and welcome back to Be Advised. Tonight we're doing part 2 of our deep dive into the death of Juston Root. Allegedly, well, the cops say that it was self-yeeting by police. I'm leaning more towards murder. Look, I will absolutely preface this to start with, and I want to give a very, very special thank you to Anne, who has sent through an absolute plethora of a research goldmine for me. There's a good chance it's going to be a part 3 to this, because I have not had the chance to go through everything that's been sent to me, and I don't have the time to do so tonight. I do have court in the morning, so I'm going to have to try and keep this to a strict hour and a half maybe. But, so what we're going to do is there's a news video we're going to look at. Then we're going to go through the reasoning for the court to have dismissed the civil case. But beyond that, I'm going to do it a little bit on the fly, because I'm going to be picking and choosing out of bits and pieces as to what we can and can't cover tonight. But let's just say this keeps getting worse. So in the meantime, where are we? Let me just make sure that I've got the social stream up, which I do. Has it finally cooled off in Australia? It is freaking freezing, Jason. Are you kidding me? We're in the middle of winter. Let's see. Hello, Flux. How you doing? You hit the notification 12 hours ago. No notification, and YouTube turned it off. Huh. Oh, and the other thing was, Kevin Albert has allegedly been relieved without pay based on oh wait, was it with pay or without pay? He's been removed from duty, basically, based on the fact that he, I don't know, left his gun and credentials in someone's car after a night of drinking. That one, you know, if we have to watch the town hall meeting, we may do that as well. Or board meeting, however you want to phrase it. Let's face it. But, I have 2 other cases for you to look at if you want. Micah Miller and Bianca Ellis. Suspended with pay, I think. Okay. Jill, just remind me, okay? But in the meantime, I just want to get into this. Where's the video? Here we go. So apparently this is the first news article where pretty much the narrative all started. Watch the town hall, it's getting wild. Okay, alright, that's fine. Well, what we'll do is we'll break up the documents, because each of them is 19 pages, and that'll give us something to smooth things out a little bit, okay? Anyway, oh, I haven't played the opener. Let's get stuck into it. fairly confident I got the right one up. Yes, and we have audio, and all right, let's go.
Boston police, the mayor, state police, the Suffolk DA updating the shooting that happened this morning outside Brigham and Women's Hospital in Boston.
The incident that transpired this morning took place over multiple jurisdictions, involved multiple law enforcement agencies, and included multiple crime scenes. At about 9:21 a.m., officers assigned to District B2 responded to the area of Vining Street and Fenwood Road for the report of a person with a gun. Upon arrival, officers were directed to an adult male suspect. These officers subsequently engaged the suspect. At that time, the suspect pulled out and pointed directly at the responding officers what appeared to be a firearm. At this time, the officers discharged their firearms at the suspect. After discharging their firearms at the suspect physically assaulted one of the officers on the ground. The suspect then got into a motor vehicle and drove up Fenwood Street onto Huntington Avenue. At this time, the police pursued the suspect. The pursuit went into Brookline, involving multiple police jurisdictions. In the area of 1195 Boylston Street, the suspect's vehicle struck multiple vehicles. At that time, he exited his vehicle, and multiple officers gave multiple commands for him to drop a weapon, which he had produced again, what appeared to be a firearm. At this time, after ignoring multiple commands to drop what appeared to be a firearm, the multiple officers, including a state trooper, Massachusetts state trooper, discharged their firearms at the suspect. The suspect was then transported to Beth Israel Hospital.
Well, that's a crock of shit. Because we watched body cam footage, it may not have had any sort of visual because the female officer whose body cam it was covered over it. Not only were there not multiple instructions for him to drop a weapon, I don't genuinely... he's injured and driving, not that it matters, but was he on drugs? I don't believe that he was on drugs. He may have been having a mental episode. That's off a cursory look at the pleading from last night. You'll have to forgive me. My brain isn't quite firing on all cylinders last night. Given I got caught tomorrow, I tried to have a nap beforehand. That may have been a bad idea. His mouth is moving, so he's lying. Pretty much.
Where he subsequently was pronounced. At the same time of the original incident at Vining and Fenwood, the officers were made aware that a approximately 49-year-old employee of Brigham and Women's Hospital suffered what appeared to be a gunshot wound. This victim was taken to Brigham and Women's Hospital and treated. He is currently now in critical condition due to his injuries. Obviously, this took place at a busy time of day, early in the morning, people going to doctor's appointments and people going to work. Obviously, people were impacted by this. We're asking anybody that was impacted by this incident to call our Boston Neighborhood Trauma Teams at 617-431-0125. We're all asking for the public's help. Anyone that saw anything, up including videos, to contact the Boston Police Department at 617.
Yeah, because God knows that the Boston Police Department don't have their own videos for it. Jesus. Sorry, I'm just pausing every now and then for copyright claim purposes. So, honestly, this is just astounding the way that he's lying through his teeth. I mean, don't get me wrong, he probably hasn't had this guy's probably just providing an update based on the information that's being provided and whatever else, but the fact that the narrative was so twisted even at this stage, it's honestly disgusting.
7-343-4470 or our tip line,
Mr. Rogaine.
434-TIPS. I want to get it out there that this is believed to be an isolated incident. There is no threat to the public as a result of this incident. I also want to mention several Boston police officers were transported to local area hospitals for evaluation and have subsequently been released. At this time, I'm going to turn it over to Colonel Mason from the State Police.
Thank you, Chief. So I'd like to speak just to the Massachusetts State Police involvement in today's incident. Massachusetts State Trooper was positioned in such a way as to be able to join the pursuit as it left the area of Brigham and Women's and traveled along Route 9 West into the Brookline area. The trooper joined the pursuit. Following the crash of the suspect vehicle, the trooper was able to join with Boston police officers and engage with the suspect. At that point, the trooper discharged his firearms, and that matter obviously remains under investigation. I can report that the trooper sustained no injury, that he was medically evaluated and cleared. The Norfolk SPDU, or State Police Detective Unit, will be conducting the investigation into the death. They'll be conducting that very closely with Boston Police Department investigators. I anticipate that there will also be significant coordination with both the Norfolk District Attorney's Office and the Suffolk District Attorney's Office. Today is the start of that investigation. It's in a very preliminary stage, and I do not have answers to many of the questions that I anticipate that you will have. I can tell you that there will be significant work that is still being done at the scene in Brookline. I anticipate approximately 2 to 3 more hours for that scene to be processed, for a search warrant to be executed on the suspect's vehicle, and for all the ballistic evidence to be collected. We are asking that if anyone has any video or was an eyewitness to the Brookline scene, that they contact the Norfolk Suffolk SPD State Police Detectives Unit at 781-830-4800, 781-830-4800. And again, for the next 2-3 hours, we'll be working that area in Brookline, and so motorists can expect delays and should probably avoid that area. Thank you.
Good afternoon. My name is.
I'm not gonna lie. I get that it's in. I get that it's not in the same place and that it's not whatever. But the Brookline thing just makes me think that Jesus, this must be what people in America must think Australia say Brooklyn like. It's like, oh my god, that's hurting my head. Just need the snow image. Wait, was there snow?
Good afternoon. My name is Dan Mulhern. I'm the First Assistant District Attorney on behalf of Rachel Rollins. With me today is Ed Zabin, the Chief of our Homicide Unit, and Lynn Beelan, the First Assistant District Attorney from Norfolk County. I'd just like to report to all of you that District Attorney Rollins has been in touch with District Attorney Morrissey, and both of them, and on behalf of all of our law enforcement officers and other members in the audience, pray for a speedy recovery for the gentleman that was hurt at the Brigham and Women's Hospital today. Our role, in conjunction with the Norfolk County District Attorney's Office, is to investigate what took place here in Boston and in Norfolk County over into the
This is why I feel stupid saying it like that.
I cannot say enough about the efforts of the Boston Police, the Massachusetts State Police, the Brookline Police Department, and the Newton Police Department in their response, both to the scene in Boston and to the very complicated scene in the Brookline area that many of you are aware of.
Yeah, Leafy, we'll talk about that in a bit.
Lastly, I'm very confident that we will move slowly, work in conjunction with all of the partners.
Move slowly.
Here, step by step.
Did this dude literally just say they'll move slowly? I mean, yeah, sure, okay, fine. In the Reed trial, Proctor had already decided who had done what within 16 hours, but I kind of feel like this one might be a little bit more cut and dry, and you're talking about working slowly? You wanker.
Step to put the pieces of this puzzle together for you all, and we're confident that we'll be able to give you answers as the investigation moves forward. Thank you.
Thank you very much for covering today.
Hate that it opens things in the wrong
way that
tab.
Any of us expected Friday morning to start here in the city. I want to first say that on behalf of the city of Boston and town of Brookline, our prayers go out to the victim here. Hopefully that he's in one of the best hospitals in the world, Beth Israel Hospital. Brigham Women Hospital, and hopefully he'll be a speedy recovery. I want to commend the work this morning of the Boston Police Department. I spoke to Commissioner Gross as the incident was unfolding. The State Police, District Attorney Rawlings, as this was moving forward through the city of Boston into Brookline. Incredible work. A lot of danger out there. A lot of people put their life on the line. The men and women of our police departments, I want to thank them for all of their work here today. And also, Brigham and Women Hospital, I had a conversation with the president of the hospital right as this incident happened. I spoke to her several times since then, trying to figure out what was this all about. But it's a very unfortunate incident that happened here. And we're going to work with the DA and the Boston Police Department, State Police, and Brookline to figure out how we move forward here. But I'm just asking everyone to keep this person, the victim, in our thoughts and prayers as we get through the next few hours here in the city. And with that, I'll turn back over to Chief Long so he can take any questions.
Where was the first confrontation between the suspect and someone at the hospital? Why? Can you describe those circumstances again that you described?
What I can tell you right now, obviously, it's a very fluid investigation. We're working that we're interviewing a lot of witnesses. All I can tell you is the first confrontation with the police and the suspect took place right at Fenwood and Vining, right at the corner.
Where were the shots before?
It's under investigation. We were directed. There was a 911 call for a person with a gun, and when the police officers arrived, they were directed to the suspect.
Where was the victim from, employee from Birchmore? Was he at that intersection, or was he further up?
He was actually standing. He was standing at the entrance of Brigham Women's Hospital.
So he was shot up the street.
He suffered his apparent gunshot wound right in front of the hospital. Yes.
Was the valet injured during the exchange of gunfire between police and the suspect?
Right now, it's under investigation. Like I said, we are going through a ton of video, a lot of witness interviews. So it's still preliminary. Like I said, it's under investigation right now.
What kind of gun did the suspect have?
Sorry, I know I'm not talking as much as I should do. I'm trying to do things on the fly, which includes going through this amazing document that Ian sent me. It's like 300 megabytes, and it's got like various videos and all that sort of stuff that I could not find yesterday. Including it's got and like I'm just trying to work out what I can and can't show and what's appropriate. But there's very much video of I kind of feel like I need to show the bit about Goblin throwing his video cam. Yeah, this just keeps getting worse and worse, if I'm perfectly honest.
Under investigation right now.
You can't tell if it was a BB gun or a lack of better term, a real gun?
Like I said, right now they're still processing the scene right now, multiple scenes. So I just couldn't provide that right now.
Was the car the suspect's own personal vehicle, or did he carjack it?
No, he didn't carjack it.
It wasn't the good cop that testified. No, thank God for that.
Why was he there, the suspect?
Again, it's we're working through that right now. What brought him to that area? I couldn't answer right now why he was there.
You also said that one of the officers was injured, that he injured one of the officers. How did that happen?
So what happened is after the discharge, he actually physically assaulted one of the officers. There was a physical confrontation before he then disengaged and then got into his vehicle and drove away.
Was anyone from the hospital security?
Sorry, can't answer questions. Still planning evidence. I mean, all this really goes back to is complete and utter negligence and incompetence by the police force, which is terrifying. I mean, I'm reading through the notes here about Godden losing his gun or swapping it out for another officer's. He didn't notice that he retrieved someone else's firearm from a different locker than they initially put it in. Didn't know the 6-digit serial number on his department-issued firearm. Where are we? I reported to work on Friday, February 7 for my regular tour of duty during the day. I was assigned to the booking desk. I placed my department firearm in the gun lockup located in District B2 outside the booking area prior to entering the booking area for my assignment. At the end of the shift, I unlocked what I believe to be the same lockbox using the same key that I had in my personal shift and recovered what I believe to be my department-issued firearm. Seriously, that is insanity because either the same key opens multiple lockboxes, which shouldn't be possible, or those lockboxes are nowhere near as secure as people allege them to be either. Oh, Stingy, you need to get off your ass and get working, dude. I need the video of the town hall board from yesterday with Albert getting yeeted. Well, not yeeted. You know what I mean. I'm being a dick. It's fine. Where are we? I unlocked what I believe to be the same lockbox using the key I had on my person all shift and recovered what I believe to be my department firearm. On today's date at about 1:45 p.m, I was contacted to verify my department-issued firearm serial number that was in possession at home. At this time, I noticed I did not have my department-issued firearm bearing serial number blah blah blah, but had serial number such and such. Lieutenant Driscoll then ordered me to respond to District B2 to document the situation on Form 26, turned over custody of the department firearm along with its one magazine and ammunition to Lieutenant Driscoll. Holy crap. How long had he been walking around with someone else's gun? I'm not 100% sure because there's not a date on this. When was... See, and this is why I'm going to have to take the time to go for a deep dive into all these documents so I can collate it all into a specific thing. But for what it, I mean, it's bad enough that it was longer than a day. The fact that he had to be contacted by someone else for him to realize he was carrying around someone else's gun is terrifying. Rumble exclusive? Maybe. We'll see. Young jerks have the meeting on their channel. Okay, cheers. Appreciate it. Incompetent cops planting evidence. No, say don't so. Well, you know. The guy accidentally grabbed someone else's firearm? Yes. Accidentally, apparently. So the whole time, Godden did not turn his body-worn camera on, did not check Root's license plate number, which we will see that there's car footage as to exactly when he could have done that. He didn't seek or take cover, didn't establish perimeter, didn't de-escalate or use any diffusing techniques. Good God. Didn't attempt to talk to Root, didn't take a proper stance with 2 hands on the firearm. This is terrifying. I'm trying to work out what the... Okay, so that's video footage of him from a different angle. Playing grab ass can lead to swapping firearms in the morning. Do you want to... Oh, grifter! Proves me right when I keep telling everyone there's more than just a few bad cops. Yep. Why was the case dismissed? That's what we're going to get into, because... So, like I said, the main things that I wanted to look at today were the city's response and then the the court's reasoning as to why they dismissed the appeal. I'm going to stick with that because there's so much of a treasure trove here. But what I'll do is I'll intersperse it because the documents are so long. I mean, 19 pages, and I can't really skip over things. I'm going to need to scan over it to actually know the entire detail. So I'll break it up. We'll watch the town meeting in between the two, just so we can see exactly what happened with Albert being relieved of duty as well. It's fine. Stingy, it was a joke, dude. Relax. Okay? All right. So let's start with, this should be the City of Boston's answer to the complaint. All right, so this is 14 pages. Then we'll do the county board meeting, whatever the hell it's called, and then the court's reasonings for dismissing it. Okay, so preliminary statement. Paragraph 1 is a preliminary statement to which no response is required. To the extent that a response is required, the city admits Juston Root was shot by Boston police officers on February 7, 2020, but denies that Root was unarmed on the ground at the time. The city is without knowledge or information sufficient to enable it to admit or deny the remaining allegations in the first sentence. The city admits that Root did not flee in the moments before he was shot in Brookline. Well, no shit, he'd lost 2 liters of blood and was stumbling around. The city admits that Root did not point a weapon in the moments before he was shot in Brooklyn, but denies that Root did not brandish a weapon. Okay, so they were countering, saying that he had the gun out and was brandishing it. The city denies that Root did not make any threatening or overt acts towards the individual defendants or anyone else. The city denies that Root posed no immediate threat to harm anyone. The city admits that several Boston police officers discharged their firearms at Root, but denies that they did so without warning. We've heard the body camera footage. You got an ad for pizza? Sweet. The city is without knowledge or information sufficient to enable it to admit or deny the remaining allegations within the 6th sentence. The city denies the remaining allegations in paragraph 1. Damn it, I kind of feel like I need to do this side by side and do so that we know what they're claiming. Paragraph 2 is a preliminary statement to which the response is required. To the extent that the response is required, the city admits that there is video footage that was recorded immediately after the shooting, but denies remaining allegations in the first sentence. The city denies the allegations in the second sentence. As to the remaining allegations contained in paragraph 2, the city states the video footage speaks for itself. Damn it! I'm gonna have to do this. What do you call it? Do I know there's a Twitter page following me? Yeah, probably. I think the Justice for Justin page followed me earlier today. All right, what do I need? I need Pacer. Oh, hang on, it's probably in the thing that was because I can't. It's probably the first, I think this might actually be the first time I've read a defense, or at least this style of defense anyway, because it's going to be annoying as hell without seeing what they're agreeing to and denying. I'm going to need the complaint. Where are we? Bannon and Gordon, complaint. There we go. Now, this is going to be annoying as shit, but I'm going to have to be jumping between the two. Okay. Okay, so paragraph 3, based on its conduct and described in greater detail below, the estate of Root has brought the present action against the individual defendants in the city of Boston for violating Root's rights under the 4th and 14th Amendments of the Constitution. Massachusetts Declaration of Rights and the Massachusetts Common Law. By this action, the estate seeks to shed light on precisely what transpired on February 7, 2020, to hold the defendants accountable for their wrongful conduct, and to ensure that the appropriate remedial measures are taken. Okay. City denies any allegations. As to the remaining allegations, the city says the video footage speaks for itself. Paragraph 3 is a preliminary statement to which no response is required. To the extent that response is required, the city denies the conduct of the Boston officers was wrongful. The city is without knowledge or sufficient information sufficient to enable it to admit or deny the remaining allegations. Based on the conduct and as described in the greater below, the state has brought the present action against the individuals for the violation of Mr. Root's rights under the 14th and 4th Amendments. Okay, so basically they're saying, no, we did nothing wrong, we didn't violate any rights, and we're not going to take any responsibility, which is not really shocking starting from there. Okay, so parties. All right, so... don't care about the parties. Cities without knowledge or information sufficient to enable it to admit or deny the allegations. Basically, they're saying, we know nothing. We know nothing about where Mr. Root was born, whatever. When he was 20 years old, he was diagnosed with bipolar disorder. They're saying they're without knowledge. Cities without knowledge sufficient to enable it to deny allegations in Clause 17. Okay, so they're saying that they know nothing about his psychiatric issues. City admits that 65 Fenwood Road is 1 block from the entrance of 75 Francis Street, Boston. Cities without knowledge or information sufficient to enable it to admit or deny the remaining allegations. Yep, that's fine. Upon information and belief, the BPD were called to report a person with the gun. City admits that there was a call to report the person with the gun near the hospital. City admits that Officer McMenemy did not respond to the call. The city is without knowledge to enable it to admit or deny. McMenemy decided that he didn't want to respond to the call. Ultimately, 2 officers. Goblin drove. Okay. Paragraph 22 references a photograph which speaks for itself. To the extent the response is required, the city denies that Officer Godwin drew his firearm while Root was facing away from him. I'm sorry, you what now? Damn it, we've already seen footage that showed that he pulled his weapon while Root was facing away from him. So the response is summed up as, nuh-uh, they were good cops. Yeah, which is sort of why I'm curious as to what they're sharing all my links for this. Oh, lovely. So they're claiming qualified immunity. Also, do you have this in Australia? Yes, and yes, unfortunately. City admits that upon Root pointing what Officer Godwin believed to be a firearm at him, Officer Godwin fired at Root, stumbled onto the sidewalk, and fell. Well, we saw him fall on his fat ass. City denies that Officer Godwin attempted to shoot Root again. The city is without knowledge or information sufficient to enable it to deny. Hang on. We already know that that's full of crap. we've got this. So they're saying that Godden did not draw his firearm while Root was facing away from him, and that upon Root pointing what he believed to be a firearm at him, he fired at Root and stumbled. Well, here's the footage that we've got. It's all the whole 11 seconds of it. Now, one thing that I've just noticed that I didn't last night, there, it does look like he may be pointing towards something in his belt. But he hasn't drawn it at that stage. He hasn't drawn shit at that stage. And Godden's very clearly already got his weapon in his hand. So, again, I call bullshit. Oh, hang on. Wait, no, let's watch him fall on his ass. And down. Oh, I love that it switched to Brian Albert. That's funny. City denies the characterization that Officer Godwin was not qualified to handle the Glock 22 that he used on February 7. The city admits that the firearm Officer Godwin used on February 7 was not his issued Glock 22, which has a serial number VYN765. The city is without knowledge or information sufficient to enable it to deny any of the remaining allegations in paragraph 24. Upon information from belief, his issued firearm, violation of the policy, the firearm he used was not his assigned Glock, but instead was a firearm which he would not been qualified. Hang on. Was it another Glock 22 though? All they've said was that he was not qualified to use the weapon that he had on the day. But I suppose presumably if he's mistaken it for his own weapon, then yes, it is another Glock 22, isn't it? Instead of firearm for which he was not qualified, according to Officer Godwin, he does not know how he came to be without his BPD issued firearm. During the interview conducted as part of the investigation, he could not remember the make or caliber of his own firearm. Moron. The point when he said it was a Glock 22, when asked what caliber, he said .45, but correcting the investigative officer who said that it was a 40. Okay. Paragraph 25 references a recorded interview, the contents of which speak for itself. Yep. it's a recorded interview. We can't say one thing or another, so we're just gonna have to say yeah, okay, and cop that one on the chin. Paragraph 26 references a recorded interview, the contents of which speak for itself. To the extent the response is required, the city admits that Officer St. Peter stated in his interview that he parked his cruiser at the intersection and where he fired at Root. The city admits that Officer St. Peter stated in the interview that he saw Root fall and grimace and he thought Root was mortally wounded. The city admits that Officer St. Peter stated in his interview that at some point in time he thought Root would succumb to his injuries. The city is without knowledge or information sufficient to enable it to discuss the remaining allegations. Plate refers to video footage which speaks for itself. To the extent the response required, they admit that he limped back to his car and drove away. They admit the allegations in paragraph 28. Hang on. So they're saying they don't know anything about 30 and 31, 29, 30, 31. Okay, so they're denying that that over the radio Godden said, I've shot him, I know I shot him. They're denying that upon information belief, he was not the only person shot at that morning. I'm sorry, what? They're denying that they denied that the valet got shot in the initial defense. The Suffolk County DA's office confirmed the valet was shot by BPD and is investigating. The city is without knowledge or sufficient information to enable it to admit or deny the allegations about somebody else getting shot by the police department. You know, this is one of those cases of willful ignorance. This is the point in time where you go, hang on, why exactly do you not already know that the police are looking into the fact that someone else is shot? Oh, because you didn't pick up the phone and ask. That's some shoddy work there. Defendants shot Mr. Root on Route 9. They admit to 32 and 33. 32 and 33. They chased him westbound in pursuit. Officers Thomas and Fernandez were in the same cruiser. 34. Without knowledge or According to defendant Godden, during the pursuit, he was able to fix the jam in his firearm that he was carrying. Okay, fine. Paragraph 35 refers to video footage of the district attorney's report, which speaks for itself to the extent that the city admits that a BPD cruiser operated by McMenemy struck Root's vehicle. The city is without knowledge or information sufficient to enable it to deny the remaining allegations. Near the beginning of pursuit, executed the pit maneuver. I rammed him. So basically, they're saying they didn't review any of the footage. Like everyone was kind of following him, so I came in and just boom and made a T with his hands. The city states that BPD Rule 301 speaks for itself and refers to the same for a complete reflection of its terms. Yeah, it literally says that a police vehicle deliberately striking is against the rules and procedures. So they've admitted that. They admit that Officer McMenemy struck Root's car. Root put his Chevrolet Volt back in motion, continued to drive westbound. The city denies that Officer McMenemy's behavior was reckless. It's literally against the police procedures to engage in the actions that he did, and you're saying that he wasn't reckless. Cities without knowledge or information unable to enable him. Blah, blah, blah. 39 and 40, it can't specify. So they're saying that they don't know anything about the... So they're saying they don't know about the state troopers joining the pursuit, or that he was bleeding from the gunshot wound. What do they say about the photos? Okay, so they're saying that they're without knowledge refers to photos which speak for themselves. Refer to photos which speak for themselves to the extent the response is required. The city admits that Root's vehicle came to a stop at Route 9 near the entrance of the shopping centre parking lot and was severely damaged. Cities without knowledge or information sufficient. Okay, and then they skip 43, 44, 45, 46, and 47. Which is, so they're basically saying anything that we can deny knowledge of, we're going to. Defendant Trooper Connelly saw the collision and observed Mr. Root's car travel through the intersection. Seconds after the stop, the driver opened the door and began to exit his vehicle. So they're saying they have no knowledge of that. At the time that Root's... Okay, and they're saying they know nothing about the EMT. And they've got no knowledge of anything that the EMT said to the investigators. Bloody hell. 48 refers to video footage which speaks for itself. They say that the city admits a woman approached Root and one or more officers ordered her to run away and she did so. And they're otherwise without knowledge. Cities without knowledge. Paragraph 50 refers to a recorded statement which speaks for itself to the extent the response is required. City admits that at one point Officer Godden observed Root lying on the ground. The city admits that Officer Godden observed a woman going up to Root, but he denies that he knew the woman was an EMT. I don't think it was ever alleged that he knew she was an EMT, did she? Did he? Did they? Are you serious? That's really what you're quibbling about? They said he also saw the EMT trying to help. They said that to specify that she was an EMT just for the sake of it, and they're actually nitpicking and like cutting the straws, saying, "Well, he saw somebody, but because you've described her as an EMT, we're going to dispute that fact because we can't say that she was an EMT that he knew." Well, whether he knew she was an EMT or not at the time is irrelevant because she still was a retired EMT. I need to move the chat over here because I'm missing a whole bunch of crap while I go through this. Where are we? Okay. MT ran away, walked forward, directly standed over him, crashed on the ground while... Okay, so 51's going to be an interesting one. What do they say? The city admits that Officer McMenemy walked towards Root and later put his foot up like at a 90-degree angle and kicked Root down to the ground, but denies the remaining allegations in the first sentence. Okay. Walked towards him, was standing directly over him as he crashed on the ground while in position to... Wait, what? So what they've said is that they acknowledge that he put his foot up and kicked him to the ground, but he was not in a position to observe Root's significantly impaired condition by being close enough to kick him to the ground. And that he was then stepped back and joined by the other officers, and they formed a line a few feet from Root. If you're going to deny everything else, why would you admit to that? And yes, both Godden and McMenemy are trained, certified EMTs before becoming officers. I did see that. Thank you, Anne. City admits that the officers collectively and simultaneously screamed commands, including "get down and let me see your hands," while they were in the mulched area. The city denies that the commands were unintelligible. Having heard those commands myself, yeah, they frickin' were. The city's without knowledge or information sufficient to enable it to deny. 52, 53. So they're saying they know nothing about the bystanders. Defendant Godden admitted that he and other officers yelled conflicting commands. Okay, what do they have to say about that? Paragraph 55 refers to a recorded statement which speaks for itself. To the extent the response is required, the city denies that Officer Godden and others yelled conflicting or confusing commands, but admits that Officer Godden made statements that identified in paragraph 55 to law enforcement investigators, though additional parts of these statements to law enforcement officers are omitted from paragraph 55. Well, he did say that, but that's not everything that he said. The city admits the officers screamed for Root to get down, but denies the remaining allegations in the first sentence. They deny the allegations in the second sentence and deny that Root was helpless and incapacitated, but is without knowledge as to the remaining allegations contained in this third sentence. They admit that Root did not point a gun at that point in time, but deny that Root did not brandish a gun or any other type of weapon at the officers. So they're trying to justify that they shot him because he didn't point it at anyone. But here's the thing. I mean, look, yes, in the circumstances, it may be slightly different, but take it in isolation. If someone's walking down the street and they just happen to be waving a gun around, is that an excuse to put 31 bullets in them? I don't really think so. So not only did they shoot him loads, they also kicked him. At least once, yes. Which has been admitted to. The city admits that Boston police officers fired at Root from a few feet away. The city denies that it was done without warning. Well, there was no warning. We heard it on the body cam. City is without information or knowledge unable to admit or deny how many shots were fired and within what time frame. City denies the remaining allegations in 57. Denies the allegations in 58, which is that 31 fire. So they deny that he posed no immediate threat and many alternatives for the use of less than lethal force were available to the individual defendants. No information, and they acknowledged 64 video footage captured law enforcement officers' conversations and contacts after the shooting, which we know. 65 refers to the video footage, which speaks for itself. Yes, it does. To the extent that paragraph 66 refers to video footage, that footage speaks for itself. To the extent the response is required, they're without knowledge to admit or deny. Basically, they're saying, you know what? What's caught on camera was caught on camera, and we have to grin and bear it. So, if you ask the cops, yes, that's an excuse, like the cop that vented the airman that answered the door with a gun. Oh yeah, that's true. I completely forgot about that case too. Video footage. They admit the officers communicated over radio about the status of the pursuit. The city's without knowledge or information. Denies the allegations contained in first two sentences. Individual defendants and other officers involved in the pursuit and shooting were acting independently and without regard for how each other was approaching the pursuit. Mr. Root's apprehension or the shooting. The individual defendants were unaware of which officers had arrived at the scene and were unaware of where other officers were standing and were unaware of who shot Mr. Root. It's pretty damn clear from the footage that they do have that those sentences are justified. The officers had no idea who was there, and one of the guys is going, well, I was freaking worried about crossfire, so clearly at least one of them had no idea where anyone else was. City states that BPD Rule 405 speaks for itself and refers to the same in the full recitation. They admit that Officer Figueroa activated a body cam before the shooting. The city is without knowledge sufficient to enable it to deny the allegations in 78. All five had been issued with body cam footage. Contrary to the policy, only Figueroa activated. Although she didn't activate it at the outset of the pursuit, she was doing it as pulling up the area. Defendant Officer Figueroa, however, wore her body camera footage in such a way that it was largely covered when she approached and shot Mr. Root. She turned her camera off approximately 5 minutes after the shooting. Okay, so basically saying, well, we know nothing about anything else. They deny that Officer Thomas was wearing body camera during the incident. The city admits the remaining allegations in paragraph 79. Wait, so what? They're denying that Thomas had it at all. So they're denying... There's body camera footage from one of the officers, but they're denying that he had a body camera on him. That's interesting. City admits the allegations in paragraph 80. Reported to law enforcement investigators that after the shooting, they were not wearing their issued body-worn cameras at the time of the shooting. Okay, so they admit that at least 2 of them were not in a position where they were supposed to be handling it. All right, I'm not going to worry about the rest of the counts because we've already been through that. Because they're just going to go back and say, no. No response is required, no response is required, city report. Okay, to the extent that it alleges the city failed to train its police officers or implement proper procedures, those allegations are denied. Not shocked by that. Okay. City asserts the following for affirmative defences. Plaintiff does to state a claim which relief may be granted. City at all times acted in good faith upon reasonable belief in it that its actions were in accordance with the Constitution and the laws of the United States and the Constitution of Massachusetts. Plaintiff's complaint fails to state a federal civil rights claim against the city under the doctrine of Maryland Department of Social Services. Plaintiff's complaint fails because the city did not maintain a well-settled municipal practice whose implementation was deliberately indifferent to the constitutional rights of the plaintiff. The plaintiff's complaint fails because BPD did not maintain an unconstitutional policy. Plaintiff's complaint fails because no decision or action by an official vested with policymaking authority was deliberately indifferent to the constitutional rights of the plaintiff. The city is immune from suit as it was engaged in discretionary functions. None of the city's acts or omissions were a proximate cause of injuries or damages, if any, allegedly sustained by the plaintiff, nor were there any alleged injuries or damages caused by any person or entity within the city's responsibility or control. The city is a municipal corporation, its liability, if any, is limited by statute. The claims are barred because of because of sovereign immunity. Jesus. Imagine if something like vicarious liability could be completely removed because of sovereign immunity. Damn. Plaintiff's claims are barred by the applicable statutes and limitations. City reserves the right to amend its answer and assert such other further defences may become available or apparent during the pretrial proceedings in this litigation and to rely on affirmative defences asserted by other parties to the litigation. Wherefore, the city respectfully requests that the Honourable Court dismiss the plaintiff's complaint and a judgment in its favour and grant such other relief as a court deems fit and proper. Look, not exactly unexpected as to how they phrased that. They're basically trying to pass the buck as much as possible, keep as much information to their chest as they can, and effectively deny things that, well, frankly, in my opinion, they shouldn't be denying. But it's nothing that I wasn't really expecting. Excuse me. All right, so where is this? That's 2 weeks ago. 13 hours ago. Canton Select Board meeting. Hopefully this isn't. Watch replays online at cantoncommunitytv.org. I think I'll just watch it on YouTube, if you don't mind. Although it does have the Young Jerks stuff, like... Oh, actually, hang on. I think I might be okay with that if I do that. Ha! That's funny. Alright, now I'm not going to play the whole 43 minutes of it. Do we know how far in they start talking about... Oh, screw that. It's got their, like, Rumble, the YouTube chats and stuff. Hang on. It's Recovery Addict watching it. Wait, what does it say? I might actually have to do this. CantonCommunityTV.org. CantonCommunityTV.org. Sorry, I know this is... I hate doing dead air like this, but there's not a lot that I can do about it at the second. Damn, I don't really want to use Recovery Addicts either. Oh, cheers, Flux. No, hang on. Tools, anytime, past 24 hours. Avoiding chaos. Board of Selectmen. Oh, screw it.
All right, good evening, everybody. We are resuming our open session. We had an executive session earlier, so we are just resuming our open session at 7 o'clock. But welcome to the Select Board meeting of July 9th. As a reminder, this meeting is being recorded by Canton Community Television, and our Vice Chair, Mr. McCourt, is out of town, so he will not be joining us. So first item on the agenda is again public comment. So as I have been doing previously, I will read this statement. The public comment portion of the meeting is an opportunity to listen to residents' feedback and concerns, but the public comment portion of the meeting is not meant to be a question and answer format. There will be no response to any public comment when presented. The public comment portion of the meeting is limited to 15 minutes total and 3 minutes per speaker. I would encourage those that do wish to speak to be mindful of others in the room who wish to do the same, so that we can make the most of the time allotted and hear from as many people as possible. Anyone who does not wish to speak or who is unable to speak due to the time limit may submit their comments in writing for the board's review and consideration. The Select Board will also announce the next open office hours at our next Select Board meeting. So that being said, we will begin our public comment period at 7:01. So, Ms. Smith?
Christine.
Oh, come on. You probably have concerns in these trying times. Here's 3 minutes. Oh, that isn't even me.
Of Select Board members.
That's funny.
After submitting my comments, Town Administrator Charlie Duty let me know that his office would work on this, and they thought it would make sense to perform a complete update of the administrative code, not just this one section, and that made total sense to me. I offer my sincere thanks to Mr. Duty as well as to Jen Kamelian from the Select Board office for all of their work on this issue. However, the revision to the standards, policies, and ethics seems to have gotten a little derailed. I'm not sure if the committee continue to individual on the select, not just their standard. This continued behavior. To be clear, this is not about the Reed case or any other matter.
Oh, hang on, she actually
present the town.
Fuck, lady, get onto it.
Not just the ones who voted for you. And yes, as public officials, you are held to a higher standard. This continued behavior reflects poorly on the town and has the potential to expose the town to liability. To be clear, this is not about the Reed case or any other matter. It is about leadership and leading by example. It is disingenuous to sit there and object to lack of civility when one of your own members acts in an uncivil manner with no comment or consequences from the rest of the board. Thank you.
Thank you, Ms.
I might just kick this up to 1.25. At least until we get to the interesting parts.
I'd like to reintroduce myself. My name is Colleen O'Neill, where I formerly worked at F&F Power Equipment on Walpole Terrace in Canton, Mass, alongside my longtime boyfriend, Jeffrey Farrington, a longtime Canton resident, whose father retired as captain of the Canton Fire Department. Recently, we were informed by the town secretary, Charles Duty, that our case regarding commercial vehicles parked overnight was on the agenda. Today, an executive session that was held at 6:15 p.m. tonight was held to discuss litigation concerning Walpole Terrace.
Okay, so nope. Moving on.
Sean Colburn. Mr. Chairman, I would like to address some questions I have for you guys, since we weren't afforded the opportunity 2 weeks ago to address items that were listed on an agenda with the reappointment of the police chief, and I had planned on going through and asking each one of you guys how you voted and what you some of the questions you asked her were.
Wait, what? Listen to her. Was it important? Sounded like she was. Hang on. Okay. Next three you really want to listen to, they're good. I just didn't want to be sitting here and just like staring at a screen. Okay, hang on. If it's important, I'll go back and listen to it, but
was on the agenda. Today, an executive session that was held at 6:15 p.m. tonight was held to discuss litigation concerning Walpole Terrace. Despite enduring significant harassment while working in Canton, Massachusetts, I have since moved my career to Boston, specifically working on Mass Ave, known as Massencast, where individuals facing severe drug addiction and dual diagnosis mental health disorders reside on the streets. The ongoing harassment from Canton, including unjust fines, unwarranted visits from a sexual predator, Canton cop, Eric Wade, and personal property.
Wait, what? Well, yeah, of course I'm trying to take shortcuts. I'm already 50 minutes into this thing and I got caught tomorrow. Okay, admittedly, the truth and justice for John's a bit interesting in the back. I'm sorry, what? Sexual predator Canton cop Eric Wade. Okay, hang on. Canton police Eric Wade. Something else for me to look into, apparently. Who said duty, fess up? Yeah, hey, out and about. That's why I went back to it. Okay, fair enough. I trusted you.
Issues involving another corrupt Canton officer, Charles Ray, who altered zoning regulations in 2016, has compelled me to leave the area. I now collaborate directly with the Massachusetts state government to provide housing for people with severe mental health illness. I have reached out to Governor of the Massachusetts, Maura Healey, and Boston Mayor Michelle Wu regarding Jeffrey Farrington's property on Walpole Terrace, proposing the construction of 40B housing for housing undocumented immigrants. The town of Canton has caused immense emotional distress to our business and personal lives over the past 13 years. Tonight, I speak out in hope that Canton residents will support a small business that has thrived for over 3 decades, contributing to taxes and community welfare. It is crucial to recognize that 40B housing in Canton, Massachusetts is our last option to halt this relentless cycle of lawsuits, police misconduct, and unfair fines that plague running a business in Canton, Massachusetts. This clown town of Canton has caused nothing but harassment to a small business and caused extreme emotional distress to Jeff's and I personal relationship. This harassment needs to end.
Okay.
Sean Colburn. Mr. Chairman, I would like to address some questions I have for you guys since we weren't afforded the opportunity 2 weeks ago to address items that were listed on an agenda with the reappointment of the police chief. And I had planned on going through and asking each one of you guys how you voted and what you some of the questions you asked her were.
This is insane.
How was the determination decided on to reappoint Helena Rafferty to a one-year contract? Did you interview and assess her performance one-on-one, or was it done as a group? Does the chief recognize the missteps that have occurred in the Canton Police Department investigation and the death of the Officer John O'Keefe? Can you tell us what some of the questions you asked her were? What, if anything, did you ask her about her department's lack of following proper procedures and policies? What, if anything, did any of you ask her about the importance of interviewing, separating witnesses, and recording witness statements? What, if anything, did you ask her about the collection of evidence, the proper storage of evidence, and the chain of command on evidence collection? What, if anything, did you ask her about recognizing and adhering to conflicts of interest? You know, such as when the chief at the time, Chief Berkowitz, called District Attorney Michael Morrissey's office at 8:30 a.m. on January 29th and talked about the Canton Police Department recusing themselves because of a conflict of interest. When through testimony, we learned that the Canton Police Department actually did not adhere to this recusal. We had a Canton police officer, Kevin Albert, arranging witness interviews days later after they were recused. At 8:30 a.m. on the 29th, the state police took control of this investigation. Why were the Canton police officers in the Sallyport at 5 p.m. on January 29th? And why was an ATF agent also in the Sallyport? The ATF has no jurisdiction on this case at all. Yet Brian Higgins was allowed to be there. Who were the 3 officers that were not identified at 34 Fairview? Did any of you ask her how an inverted videotape was turned in as evidence? Did any of you ask her how 40 minutes is missing off the Sallyport video?
Damn. Hey, you know what? Given the question that he's actually he is bodying these people, I'm gonna let him go with the what if anything. What if anything? Spit them back the words of Lally. Yep. This wow. Like,
how about the library video? And what, if anything, was done in regards to the testimony in the text messages read from State Police Sergeant when they were driving around the Cape in a State Police cruiser, shit-faced, and the Canton Police officer, Kevin Albert, lost control of his badge and his gun? Were they ever recovered? Was there any disciplinary action taken? I think these are just a few of the things that come to mind. This is your job to ask these questions, not mine. We are the taxpayers of this community. We should have been afforded the opportunity to ask these questions 2 weeks ago on an item that was listed as an agenda item. You're in violation of Mass Open Meeting Law. Thank you.
Thank you.
Okay, I'm going to start by saying, holy crap, that guy hit several nails on the head. But we have the red solo cups. You're telling me those are not adequate evidence collectors. The only thing that they're, the only thing that red solo cups are adequate evidence collectors of is whether or not you get the ping pong ball in there during beer pong, okay? What, if anything, shall I do for being late? Nothing. You're fine, Kathy. Starts to get spicy at the end of the next person. Okay. See, this is interesting. Like, I get this as public comment, but town meetings for us here, generally when you're addressing questions to, like, boards and that sort of thing here, 8 times out of 10, you sort of expect there to be a response, at least from, like, the city mayor or from a councillor or, like, I'm not specifically sure which, I mean, this is a select board, so it might not be the same thing there. The fact that they're not offering any response is incredibly telling, in my opinion, but it might just be that that's not how it's done, frankly. Which, I suppose it's probably not, given that they're just keeping their mouth shut on the other things, too. Ostrich's head confirmed. Oh, ostrich head's in sand confirmed. Got it. Town meetings are wild like this. They kick people out every month.
Ms. O'Donnell?
The American Revolution began in 1775 as an open conflict between the United 13 colonies and Great Britain. Many factors played a role in the desires to fight for independence. Not only did these issues lead to a war, but they also shaped the very foundation of the United States of America. The Americans felt that they should have equal rights to the Englishmen. The British, on the other hand, thought that the colonies were created to be used in the ways that best suited the Crown and the Parliament. This seems a lot like our current reality in Canton. This conflict embodied in one of the rallying cries of the American Revolution: no taxation without representation. To me, this...
Oh, no, I didn't think that she sounded crazy. I actually thought that was a really good opening. Like, pulling it in to go that far back in history and evoke the emotion of the American Revolution, that sort of thing. I'm impressed so far.
Sounds like our current day Canton. While we pay all our taxes, our services, leaders, and police departments only service the entitled, selected few, while those entitled in our governance try to silence our concerns. Another driving force behind the revolution was an outcry against the judicial system that was in place, offering yet another airy comparison, ironically enough, involving 6 British soldiers. After 6 British soldiers were acquitted and 2 dishonorably discharged for the Boston Massacre, the British government changed the rules. From then on, officers accused of any offense in the colonies would be sent to England for trial. This meant that fewer witnesses would be on hand to give their accounts of the events and led to even fewer convictions. Wouldn't it be nice to watch Proctor's hearings for his indiscretions? This makes matters even worse. Jury trials were replaced with verdicts and punishments handed down directly by colony judges. Over time, the colonial authorities lost power over this as well, because the judges were known to be chosen, paid, and supervised by the British government. Again, dauntingly familiar. The right to a fair trial by jury of their peers was no longer possible to many. John Adams once said, "Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What frightens me most is even after watching the same trial for 10 weeks, so many still blindly trust and follow the corrupt and avoid the facts and evidence that would have convicted Karen Reed. There is lack of it. To bring justice for John O'Keefe, rather, they chose to keep supporting those who have factually been proven to be corrupt and dirty.
Thank you, Ms. O'Donnell.
To those
Ms. O'Donnell, that's it.
who find our...
I'm guessing this is where it starts to get spicy, given she's going over time. Oh, Kathy Trout dropping 5 Aussie Overlaw'd memberships. Thank you. Watch your ears, people. Also, just quickly, Pause and Thunder. At that stage, no, they weren't being sent to Australia for punishment. Remember, the Boston Tea Party is the reason why Australia exists. If it hadn't been for you guys refusing to take, if it hadn't been for you guys doing the American Revolution and, not being in a place to take England's criminals, Australia wouldn't exist. It's the whole reason why we're settled, because you guys weren't taking their dregs anymore. So I know it was a joke. I still get to No, you know what? I get to talk about that. You give me an opportunity to talk about that, I'm going to talk about it. Don't compare your dirty cops to the dirty cops in Britain. I know that's not what you said, Gemma. It's still funny.
Ms.
Fight
O'Donnell,
for truth,
I'm going to ask you to
justice,
settle down.
and our American rights.
I'm going to ask you to leave,
So
Ms. O'Donnell.
unacceptable to tonight. I
Officer.
quote Captain John Paul Jones, 1779. I have not begun to fight.
Thank you, Ms. O'Donnell.
Oh, she's staring them down.
I'm following the rules. We live in America, dude. Question
Right.
upon history.
Ms. O'Donnell, please.
Talking to me, but I will stay quiet. No need to leave. Exercising my First Amendment.
Ms. O'Donnell.
Okay, I'm going to speak. I'm going to speak now.
Ms. O'Donnell, you're being disruptive to the meeting. I'm asking you to leave. Thank you.
Oh, for God's
Thank you.
sakes.
Nothing to be for. I haven't broken any laws.
Okay.
I'm answering you. I said I would stand here quietly. I will stand here quietly.
She only went over a few minutes, a minute. Okay,
If
I'm
that.
going to.
Aye.
Come on, we're in crisis for crying out loud. I know it's my imagination. I know it's my imagination.
All right, folks, please be respectful. Ms. Lombardi, this is it.
Yes, thank you. Okay, listen, Rita Lombardi, and I can't believe I'm standing here about to say what I'm going to say. My ancestry goes back in this town to the very early 1900s, and I've always had respect for the Canton Police and the fire department because my ancestors served on them proudly, and I always admired them. And I'm shocked that I'm having this discussion right now. But anyways, the issues that we've had in town relate to safety and trust issues. And last week or whatever, you approved the police chief's contract, and many of us were opposed to that. And I just want to share some of the reasons why we have trust issues here. In 2018, the Canton Police Department responded to a car accident on Pleasant Street near Meadows, but did not locate the driver. An hour or so later, a passerby located the body of Craig Casey. This last year, when questioned by a concerned citizen, Chief's rapid response was, it wouldn't have made a difference to his survival. Instead of owning his
crap!
failure.
I didn't even put two and two together. The Casey case was in Canton too. That was the body there was a car accident. He'd stumbled out of the car. He was like a few feet or something in the snow, and he died. And then the police chief came out and said it wouldn't have mattered if we found him or not because he was already dead. Because they found the car and they walked away. Oh my God, how did I forget about that? Damn. Bloody hell.
Failure. It just, that was her explanation. In 2021, the Canton
Diane, if you can, look, I'm more than open if we can get, I'm more than happy to speak to people. If at any point we know anyone that wants to come on the show, I'm more than happy to platform. Well, I mean, I've got to be fair. So either side, but, if Rita's available, I'd happily be talking to her. Snow was a serial killer hiding in plain sight the whole time.
Police Department ruled Sandra Birchmore's death a suicide. It was recently confirmed that Sandra
Here we
was
go.
in fact murdered, something many citizens already knew. Yet there has been zero acknowledgement of this policing failure by Chief Rafferty or an apology to Sandra's family that I am aware of. In 2022, the Canton Police Department responded to the scene of Officer John O'Keefe's murder. The mishandling of the crime scene, the investigation, and the evidence collection was gross incompetence at best and will be taught in criminal law classes for decades to come on how not to handle a murder crime scene. Instead of Chief Rafferty addressing these performance issues with appropriate corrective action, many, if not all involved, have been promoted. In any organization, rewarding poor performance not only damages employee morale, it increases employee turnover, both of which are extremely costly. Canton PD has an 18% turnover in the past 2 years. Oftentimes, it is your best employees who seek employment elsewhere.
Yeah, if 1 in 5 officers are moving on, it's because they don't want to be around the culture. Holy crap.
Not the performance problem. If unchecked, your organization will continue on a downward spiral. In the John O'Keefe murder trial, we learned that it was Chief Rafferty who turned over the Sallyport surveillance video to the Mass State Police. We also learned that in addition to 42 minutes missing from this footage and people disappearing from the screen, and the footage was inverted, something no one has ever heard of in their life. 6 weeks it took her to report the February accident, which almost cost the man his life, and now we're being sued for that. And we're going to get sued for all these other cases as well. Policies and procedures are great, but there's no consequences when they're not followed. Just rhetoric that we'll do better next time. That just doesn't cut it. The Canton Police Department and this town is facing countless and costly lawsuits as a result of their actions. We do not feel safe, and that is why. Okay, I'm not speaking for you because you're part of the selected few. I'm talking about me, common folks. I'm talking about me, the random citizen. That's what I'm talking about.
Thank you, Ms.
Anyone
Lombardi.
who's related to the McGalberts, you're safe, but not us.
Thank
So
you, Ms.
stop it.
Lombardi.
I'm sorry.
You.
Thank you.
Running over here. She's getting yelled at and yelling. And you stand right here.
Ms. O'Donnell, Ms. O'Donnell, you said you were going to be quiet. You got disruptive. It is time for you to leave. Ms. O'Donnell, it is time for you to leave.
Wow.
All right, can we just start our meeting? What do we do with her?
Ms. O'Donnell.
You ran over here while I was speaking out of turn. She just sat there screaming at the crowd, and the crowd screaming back at her, and stay here. No, I'm not. It is inappropriate. No, it's inappropriate. Uphold the law the way it's intended to be upheld. I'm upset because I feel I'm just
Trying to see who I can recognize in that crowd.
standing in front of me while everyone else does the same thing.
It's pretty inappropriate that he's standing there.
Ms. O'Donnell, you're meeting. It's time for you to go.
I'm right, though. I may be disrupting the meeting, but I'm right, and it's my fucking right.
Thank you, Ms. O'Donnell. Thank you.
Whoa! You go, girl.
American people, remember it.
Damn.
Thank you, Ms. O'Neill. Thank you, officer. All right, before we get on to the next agenda item,
We'll be forced to have a conversation outside. Yeah, sure. Don't make it sound like someone's going to take him out behind the barn. Like, Jesus. Even the town is using McAlbert. I know, I caught that. That was hilarious. I mean, with all the crap we're seeing on Twitter, on YouTube, on the social media platforms, where you've got people that are vehemently either side of the divide on this, the town itself seems to be ripping itself apart over this. Because we seem to be, we are seeing what is going on in Canton, and the residents themselves cannot deal with it. Bitch fight out front. Oh, I hope they get it on camera. They just came from Irish drinking club meeting. No, I think the shirts are something about, like, Justice for John. I think it had something to do with, like, the Irish heritage and all that sort of stuff. She only feels safe enough to yell at them because it's summer. It's bad. Also, guys, there's 130 of you watching. If you haven't already, just hit that like button. We like getting it over 100 likes on the show. And if you're new here, maybe just consider hitting the subscribe button. For those of you that were watching for part 2 of Justin's deep dive, we're watching this, then I'm going to look at the court's opinion as to why they dismissed the case. But I'm just breaking it up a little bit. And from the looks of it, there's going to be a part 3. Okay? Just so you're aware. Hey, Mofok, how you doing? In Lucky We Trust shirts. Oh, okay. All right.
We have 2 statements to read. So, Mr. Albert, do you want to go first?
Yeah.
Wait. You have statements to read and you waited until partway through this for that? Are you serious? There's only about 10 minutes left. The video says that it's... Oh, well, I suppose they've got, like, people talking crap, maybe.
Go first. Okay, as many of you know, I've had 2 recent verbal altercations with members of the public outside of my role as a select board. Despite the tremendous harassment, stress, and anxiety that my family, extended family, and I...
The shock and horror. Sorry, I couldn't help myself.
...have been subjected to over the past 16 months, my interactions were inappropriate, and as an elected official, I am held to a higher standard, and I understand that the residents of Canton expect public officials to always conduct themselves professionally and focus on the business of the town. I apologize for my recent reaction and will refrain from any further public incidents that I'm becoming as a member of this Canton Select Board. Thank you.
Thank you, Mr. Albert. An additional statement. Chief Rafferty has placed Kevin Albert on paid administrative leave while an outside, and please be quiet, while an outside...
Wait. Please be if you don't afford them the opportunity to applaud afterwards, that's pissy.
Independent investigation is being conducted relative to his actions in a case he investigated with Michael Proctor approximately 2 years ago. Kevin Albert was placed on leave on June 13th and will remain on leave until the results of the investigation are provided by the outside independent investigator. All right.
All right, first on the agenda for tonight, Mr. Scollins and Mr. Lynch, want to step forward? Oh,
Yeah, paid leave. That's what I was thinking.
What's that? Nope.
No, it's Scollins and Lynch.
Oh, yeah. Yeah, you guys are right.
Okay.
That's all right, you can go first. Good evening, Mr. Chair, members of the board, Mr. Town Administrator. This is the time of the year annually where we're closing the books for fiscal 24, which closed on June 30, 2024. And as is typical at year end, there are some reserve fund transfers that are required in order to balance the books to keep everything within appropriations. It's a two-part process.
Well, let's hope that that one that he's talking about is the FBI. Oh, from that on, it's just board business? Okay. All right. Well, that's fine then. Well, clearly it's still getting heated in Canton. Kevin is Chris's brother. Yes, and I believe Kevin believes some shit also went down. Because, like you said, verbal altercations. Well, that's one way of putting it. All right. So we'll exit out of that, and then we'll get to the... Where are we? Oh, no, already watched that one. Okay. Okay, so this is the court's reasonings for dismissing the case that Justin's sister brought against them, against the police officers. On February 7, 2020, Juston Root was shot and killed by law enforcement after pointing and discharging what appeared to be a firearm at a Boston police officer, and then leading police on a car chase through Boston and Brookline. I already don't like this. I already disagree with this judgment. Holy crap. Root's sister, acting as a special representative for the estate, sued the officers involved in his death as well as the city of Boston as their employer. At the close of discovery, the parties cross-moved for summary judgment. Although the circumstances of the case are undeniably tragic, the court is constrained by legal precedent and the undisputed facts to rule in the defendant's favour. Qualified immunity. Bastards. Accordingly, for the reasons that follow, the court will grant the defendant's motion for summary judgment and deny Bannon's motion for partial summary judgment. On the morning of February 7, 2020, the Boston Police Department received a call warning that a person with a gun had been seen on the grounds of Brigham and Women's Hospital, located on Francis Street in Boston. Bannon's statement of undisputed material facts... Oh, I don't need to read that. Boston Police Officer David Godden responded to the call and encountered Root, who falsely identified himself as a law enforcement officer. Root then aimed what was later determined to be a paintball gun at Godden and pulled the trigger, after someone else had already pointed a gun at him. I have issues with this. I really do. The walls are closing in on the Alberts and the others that are corrupt there. We can only hope. Godden returned fire and tripped backwards onto the street. Another officer who responded to the call, Michael St. Peter, witnessed the exchange and fired his weapon at Root. Injured, Root limped to the nearby vehicle and drove in the direction of Huntington Avenue. Godden and St. Peter gave chase while Godden reported over the BPD radio that the shots had been fired and that he believed that Root had been hit. Other officers joined the pursuit, including Joseph McMenemy, Leroy Fernandez, Brenda Figueroa, and Corey Thomas. In an effort to stop Root, McMenemy performed a pit maneuver, ramming the side of Root's vehicle with his police cruiser. Undeterred by the collision, Root continued westbound on Route 9 in Brookline, where Massachusetts State Trooper Paul Keneally joined the chase. Root collided with other vehicles at the intersection of 9 and Hammond Street, and his vehicle, at which this point was heavily damaged, came to a stop. Root exited his vehicle, leaped to the sidewalk and fell. He then got back up, walked to a mulched area adjacent to the sidewalk and collapsed. Shelley McCarthy, an EMS-certified passerby who had been sitting in her car when Root's vehicle came to a stop, ran over to assist. Root, in McCarthy's estimation, was gravely injured. McCarthy stated that during the entire time that Root was in her line of sight, his right hand clutched his chest while his left hand dangled at his side. So he was clutching his chest, and his left hand was dangling at its side. Okay. At that point, officers converged on the scene and began shouting commands over one another. McMenemy's maneuver was done in violation of written BPD policy. Officers shall not use their police vehicle to deliberately make contact with a pursued vehicle. Thomas and Keneally stated that the scene was chaotic. McCarthy heard an officer yell at her to run, and she did. Officers continued to give Root overlapping verbal commands as get on the ground, stay down, and show me your hands. McMenemy closed in and pushed Root to the ground with the bottom of his left foot. Fernandez testified that Root reached into what appeared to be a jacket and that he saw Root's arm motion like it was coming out of the jacket. Figueroa stated that she witnessed Root removing his hand out of his jacket and the handle of a firearm was shown. Godden recalled Root reaching with his right hand into his jacket and someone yelling gun. McMenemy stated that he saw Root open up his jacket, saw a floating gun in his chest, and saw Root's hand reach over to get there. These are all differing accounts of exactly what happened. This is why you can't trust eyewitness testimony. Keneally testified that Root's right hand went inside his jacket and he saw Root's hand around a black handle coming up. Fernandez, Figueroa, Godden, McMenemy, Keneally, and Thomas opened fire on Root, rapidly unloading a total of 31 rounds. Thomas did not see Root reach into his jacket, but he testified he heard one gunshot and presumed Root was shooting at the other officers, which caused him to start shooting as well. What? Hey, meme, how you doing? Interesting wording for kicked. I know, I read that. I was thinking about that too. Remember the police officer said under oath that 16 years there wasn't any murders in Canton? Yep. Just get local legislation passed that financial liability for police will be linked to police union retirement funds. See how many people won't want that as the law. I live in Malden, Massachusetts. Boston's a 20-minute drive, depending on what part of Boston you're going to. They're in all kinds of traffic. Oh, no shit. There you go, Bernice. Stay away from the cops. Just, please. So one of the officers admits that he presumes that the individual was the one that was shooting. That of itself shows recklessness and negligence by a police officer. A bystander, Dr. Victor Gerbodo, witnessed Root reach inside his jacket just before the officers discharged their firearms. Root was transported by ambulance to Beth Israel Deaconess Medical Center where he was pronounced dead. Officers recovered a BB gun with a metal rod extending from its barrel in the mulch near his body. Okay, summary judgment is warranted if the record, construed in the light most flattering to the non-movement, presents no genuine issue as to material facts and reflects the movement's entitlement to judgment on the matter as a matter of law. The moving party bears the initial responsibility of informing the district court on the basis of its motion and identifying these portions of the record, which believes it demonstrates the absence of a genuine issue of material fact. Basically, what that comes down to is you can apply for summary judgment if the case against you is so fatally flawed that there is effectively no legal question to answer. If it is so blatantly obvious that the facts or the law applied mean that you cannot be found guilty or you cannot be sued, or if they fail to plead the proper things in the complaint, then the court has a requirement and a responsibility to dismiss the case. I'm going to be interested to see what the actual discussion is on this, because as far as I'm concerned, the only way that that comes down to it is if they say, well, all the actions taken by the police officers are covered by qualified immunity, in my opinion. Because as far as I'm concerned, the other things pled raise genuine questions to be tried. If this is accomplished, then the burden then shifts to the non-moving party to establish the existence of an issue of fact that could affect the outcome of the litigation, from which a reasonable party could find for the non-moving party. The crux of Bannon's excessive force, assault and battery, and wrongful death claims against the individual defendants is that their use of deadly force against Root at the Route 9 crash scene was unreasonable and unjustified. The individual defendants contend that their use of deadly force in the chaotic, highly emotive, and ambiguous circumstances surrounding the final confrontation with Root do not violate his Fourth Amendment rights. In any event, the officers maintain that they are protected by the doctrine of qualified immunity. There it is. Qualified immunity attaches to discretionary conduct of government officials that does not violate clearly established statutory or constitutional rights of which a person reasonably would have known. Per Harlow and Fitzgerald, the inquiry into whether a constitutional right is clearly established must be undertaken in light of the specific context of the case, not as a broad general proposition. The qualified immunity standard gives ample room for the mistaken judgments by protecting all but the plainly incompetent or those who knowingly violate the law. Isn't that just one hell of a shoddy standard? Like, seriously? You like the clip of Morrissey I sent you? Thank you. It's literally all but the plainly incompetent. If you can cover up your actions as being potentially justified, it's covered under qualified immunity. God, I hate it. It's got to go. It really does. Law enforcement officers quite often are required to assess probabilities and weigh the attendant contingencies. And it is precisely such spontaneous judgment calls, born of necessity of rapidly evolving life-endangering circumstances, that the qualified immunity doctrine was designed to insulate from judicial second-guessing in civil actions for money damages unless the challenged conduct was clearly incompetent or undertaken in plain violation of established law. When faced with a claim of qualified immunity, a court may choose to first determine whether the plaintiff has alleged a deprivation of actual constitutional right at all. The threshold question in this mode of analysis can be stated as follows. Taken in the light most favourable to the party asserting the injury, do the facts alleged show that the officer's conduct violated a constitutional right? If no constitutional right would have been violated, were the allegations established, and there is no necessity for further inquiries concerning qualified immunity. Deciding the constitutional question before addressing the qualified immunity question also promotes clarity in the legal standards for official conduct to the benefit of both officers and the general public. Turning to the constitutional issue, and after viewing the undisputed facts in light of the most favourable to Bannon, the court concludes that the defendant officers did not violate Root's Fourth Amendment rights. We begin with some basic Fourth Amendment principles. All claims that law enforcement officers have used excessive force, deadly or not, in the course of arrest are to be decided under the Fourth Amendment standard of reasonableness, the proper application of which requires careful attention to the facts and circumstances under each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. See, and the trouble is I don't even want to say this. Given the fact that he just engaged in a car chase, given that he had allegedly just shot at an officer with a BB gun, the judge's reasoning in this is, like, not flawed, which is really disturbing. And this is why it needs to be removed entirely. Because I'm sorry, if you are engaging in actions, if you make the choices and whatever, if you are vindicated, it doesn't matter if qualified immunity applies because you did the right thing and therefore you should not face any sanctions. That's the thing that annoys me, is that the point of qualified immunity is to protect police action in all cases just because, it might have been tough for them to make a call at the time. Who cares? If it was the right call or the wrong call, still affects the individuals. And there should still be responsibility and culpability for it. The standard by which excessive force is to be gauged is an objective one. An officer's evil intentions will not make a Fourth Amendment violation out of an objectively reasonable use of force, nor will an officer's good intentions make an objectively unreasonable use of force constitutional. So basically what they're saying there is that if you've got, to use Jeff's favourite thing, if the mens rea is that you can get away with killing someone using reasonable force in the circumstances, you can do so because your intent is irrelevant. That's fantastic. Okay. Officer attempted to subdue violent, mentally ill suspect and reasonably resorted to deadly force after being unexpectedly fired upon. Where the substantive liability of qualified immunity is at issue, the Supreme Court intended to surround the police who make these on-the-spot choices in dangerous situations with a fairly wide zone of protection in close cases. The officers were aware that Root was reportedly armed and dangerous, having pointed what appeared to be a firearm at Godden and pulled the trigger during the hospital confrontation. Further, Root had just fled the initial crime scene, leading the officers on a dangerous car chase through a densely populated area, culminating in Root's violent collision with vehicles driven by civilian passerby. Yep, fine. Despite Root's injuries, the officers had reason to believe that Root continued to pose an immediate threat to themselves and to the public. The threat of danger was escalated when Root reached into his jacket, an action that the officers reasonably interpreted as an attempt to retrieve a firearm. Given the circumstances, the officers had a reason to believe that Root was armed, and his behaviour would lead almost anyone to believe that he was reaching for a weapon. Whereas here, the officer had probable cause to believe that the suspect poses a threat of serious physical harm, either to the officers or to others, it is not constitutionally unreasonable to use deadly force. Shit. Bannon's provided no evidence to rebut the officer's testimony that Root was reaching into his jacket before the officers opened fire, because there would be no one that could provide it. Yeah, but I mean, if you're going to resort to fugu fish, then, you know, there's easier ways to do it and get away with it. Qualified immunity is BS, should be reviewed by an independent board. Yes, that would be fine by me. Where's your qualified immunity, says Fiery. Police don't want time, distance, cover training at the bow of the fifth column points out. Technically, it's the fish that murdered them. Well, it depends whether or not it's you that provided the fish to them. So. Join the Canton Police Force. No audible statement he had a weapon on him or that he was reaching. Hey, last night we listened to the audio. I didn't hear gun, gun, gun. The case of Bannon relies on in support of her argument that deadly force was unreasonable. Woodcock v. Bowling Green is inapposite. There, the Sixth Circuit explained that the use of deadly force where the decedent had a hand in his pocket was objectively unreasonable because the officer may have thought that he had a gun, but the decedent never gave the officer for a reason to think he would use it imminently. Unlike in Woodcock, Root was observed to be reaching into his jacket, an affirmative action that gave the officers reason to think that Root had a firearm and that it would be used imminently. Although McCarthy testified that Root's hands did not change position while he was in her line of sight, she turned away to run at officers' commands and did not see that what Root's hands were doing at the time the officers started shooting. Moreover, although Bannon takes issue with the self-serving nature of the officer's statements, self-serving deposition testimony may properly be considered on summary judgment. In any event, the court does not have to simply take the officers at their word. Dr. Gubardo, a disinterested bystander who witnessed the events, stated he saw Root reach into his jacket immediately before the officers opened fire. Bannon argues that the officers failed to provide Root with a clear verbal command, that they did not try to take cover, use any de-escalation techniques, or use less lethal force options like OC spray or a baton or warn. That deadly force may be used. That may well be true, but as the officers point out, the calculus of reasonableness in the Fourth Amendment context must make allowance for law enforcement to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Finally, the court rejects Bannon's contention that the number of shots fired at Root by the 6 officers in rapid succession lasting over only a few seconds was constitutionally excessive. If police officers justified in firing a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended, per Plumhoff and Plumhoff v. Rickard. While the forceful outcome of the constitutional analysis is, to my mind, conclusive, for the sake of completeness, I turn to the defendant's officers' qualified immunity claims. Because of the fact-intensive nature of the inquiry, it comes to excessive force when it comes to because of the facts of the nature when it comes to excessive force claims, qualified immunity doctrine has a special bite. In Kisela, the defendant officer used deadly force to subdue a woman wielding a large knife in the perhaps mistaken belief that she posed a threat to another woman at the scene. The Supreme Court faulted the lower court over its overall reliance on its own less than clear precedent. If anything, the court concluded the precedent favoured the officer. While they post-date the encounter with Root, two cases, one from the Supreme Court and the other from the First Circuit, are squarely on point, and based on numerous cases that predate the encounter. The city of Tulaqua, Oklahoma versus Bond, officers were called to a scene of a domestic disturbance. They encountered Rollis, the trespassing and intoxicated ex-husband of the complainant. When Rollis retreated into his ex-wife's garage, the officers followed. Rollis refused the officers' commands to stop walking. He then grabbed a hammer from a workbench with both hands and turned to face the officers in a fighting stance, as if preparing to swing a baseball bat. I would argue that that is separate and different to this, if I'm frank. Jury is the fact finder, not the judges. This is why it should be at trial. I'm inclined to agree with you on that, Anne. If Goldman was so afraid, why is he the closest in the line of fire to Root? He was literally almost on top of him. Ninth Circuit panel ruled that the district court had committed error in dismissing Rollis's estate's wrongful death claim on qualified immunity grounds. The Supreme Court rejected the circuit's theory that the officers had provoked the confrontation by cornering him. Rather, the court held that the officers were entitled to qualified immunity because neither the lower court nor the respondent had identified a single precedent finding a Fourth Amendment violation under similar circumstances. Recent First Circuit decision, State of Rahim v. Doe, is similar, if not greater import. Rahim, a terrorist suspect, was overheard by authorities expressing in a phone message to one of his Confederates his frustration at the slow pace of a planned terrorist attack in New York City and his determination to undertake a vigilante attack. Why am I rushing? Breathe. A vigilante action against the boys in blue right here in Massachusetts. How is that more on point? Surveillance team was notified and informed that Rahim was armed with a knife. The team was ordered to stop Rahim from boarding any public transportation. At 7 a.m., the team followed him from his apartment to a bus stop in front of a CVS on Washington Street. The officers approached him with their weapons drawn and ordered him to put his hands up and drop the knife. He refused and began advancing on the officers as they retreated through the parking lot, taunting them as he did so. Given the constellation of events, the majority of the First Circuit panel determined that an objective officer would conclude that he had chosen to escalate the situation and that Rahim was an increasing threat. and Raheem's actions were consistent with his words. He kept advancing on the officers despite their attempts by retreating to not let him close the distance. When he had come close enough to them to be a lethal threat to the officers and others, he had a split-second decision to make about what was needed to stop him, and two officers almost simultaneously reached the same decision. Doe 1 fired twice, Doe 2 fired once. Raheem was hit. The entire encounter unfolded in about 30 seconds. Mr. Boland says his co-worker that he does not know how Dr. Victor could see what he saw. Oh, interesting. So we've got potential witnesses that are fabricating stuff as well. District Court denied the officer's claim for qualified immunity, holding that a grant of immunity would be warranted based on the events of the confrontation itself, but not when consideration was given to the information gathered by the officers in the days leading up to the fatal encounter, including the plans, actions, observations, and means available to respond. The First Circuit reversed, holding that the District Court had erred in importing events that had occurred prior to the fatal shooting into the analysis rather than focusing on the moment of the shooting. Okay, so the First Circuit made the argument that they could only take into account the exact moments when the police officers shot, as opposed to the preceding factors, as to whether or not it was premeditated, as to whether or not there was... I don't like that. I think that leaves room for error as well, if I'm perfectly honest. You've never used a hammer like a baseball bat? Well, clearly you've never had a really stubborn nail. When viewed in the proper focus, the court held that a responsible officer at the situation of the moment would have understood Raheem to have a lethal knife in his hands and would have understood Raheem's actions to show that he had every intention to use the knife to kill others, and if they were unsuccessful in stopping him, to kill other people. The propriety of the grant of qualified immunity, moreover, was justified in light of the ample precedent, citing the other cases. Applying the same analysis used in the city of Tulakwa and Raheem to the facts at hand, the case for qualified immunity is even more compelling, particularly in light of the officer's reasonable belief that he was armed not with a hammer or a knife, but with a gun that he was prepared to use. So what they're basically saying is that the court, taking into account that they should ignore the fact that he'd been previously told that, taking into account that the police had been previously told that he kept a BB gun and a paintball marker on him, they have to take it in isolation and ignore that fact, irrespective of the fact that it's been entered into the database. And for the purpose of qualified immunity, the police were entitled to believe that it was a legitimate weapon and that he was trying to pull an actual handgun, irrespective of whatever knowledge they may have had. Okay, excessive force by McMenemy. Bannon first challenges McMenemy's use of the pit maneuver on Root's vehicle during the car chase as an excessive use of force. Although his blocking maneuver was in clear violation of BPD policy, and action under Section 1983 may not be based on the violation of state law or an internal department regulation unless the act complained of also violates a secured federal right. Yeah, okay, so she... Well, yeah, well, I mean, unfortunately that needs to be struck and replayed elsewhere. There's no federally secured right under the 4th Amendment or the 14th Amendment to be free from police pursuits. County of Sacramento v. Lewis, we hold that the high-speed chases with no intent to harm suspects physically or to worsen their legal plight do not give rise to liability under the 14th Amendment, redressable in any action under Section 1983. Police officers' attempt to terminate a high-speed car chase that threaten the lives of innocent bystanders does not violate the 4th Amendment, even when it places the fleeing motorist at risk of serious injury or death. Here, as in Scott, the traffic video footage shows Root driving at a high rate of speed through a heavily populated area. The danger to Root's vehicle posed to the public was underscored by the violent end of the chase, which saw Root colliding with two vehicles driven by a civilian passerby. Thus, the court concludes that McMenemy's pursuit of Root or his resort to a pit maneuver did not violate the 4th Amendment. The court also rejects Bannon's argument that McMenemy's use of his foot to push Root to the ground at Route 9 was constitutionally unreasonable. Not every push or shove, even if it may later seem unnecessary in the peace of the judge's chambers, violates the 4th Amendment, per Graham. Massachusetts Civil Rights Act provides a cause of action for any person whose rights under the Constitution, of federal law, or state law have been interfered with by threats, intimidation, or coercion of others. Because as discussed above, Bannon has failed to demonstrate that the officers violated any constitutional provision or law. The Civil Rights Act claims also fail. Moreover, the court notes that it cannot discern the presence of threats, intimidation, or coercion in any of the officers' challenged actions. City argues that Bannon has failed to establish a triable issue, that it failed to properly train and supervise the officers such that they're liable under 1983, and the court agrees. That was always going to be the weakest argument that she had. How do we go from hammer to a gun? Well, basically what they're saying is that it's already been previously found in precedent that if someone comes at a police officer with a hammer, that it is a reasonable enough threat for them to use excessive force and end someone's life. Because they were able to use it as a example, well, they're saying, well, a gun's slightly more of an immediate threat because it can cover a distance. It's effectively a ranged weapon. Again, in this instance, I'm not sure I agree with them, but this is why qualified immunity needs to go. It really does. Excuse me. Foundational element of municipal liability under claims of 1983 is the occurrence of constitutional deprivation. Here, Bannon has not demonstrated that any BPD officer committed a constitutional deprivation of Root's rights. It follows that Bannon's municipal liability claim cannot stand. For the foregoing reasons, the court allows defendants' motions for summary judgment on the finding that no Fourth Amendment violation occurred, or in the alternative that qualified immunity attaches to the defendant's actions. Bannon's motion for partial summary judgment is denied. God, that's some bullshit. You can't just shoot because someone has a gun. No, I wholeheartedly agree with you on that. As far as I'm concerned, the situation that they found themselves in, they very much should not have shot him. Even if he was reaching into his... Even if he was reaching into his jacket, which, from the sounds of it, he may well have just been reaching over to clutch his hand to his chest or whatever else where he was injured. The fact that one officer's sitting there going, well, I saw him put his hand around the base of the gun. Well, we all know that eyewitness testimony is not exactly infallible. And we know that cops lie, particularly in Boston. So, I'm calling bullshit. And it's a... What's that? First Circuit brief appeal lays it all out, refers to Supreme Court cases. No, I appreciate that, Anne. I literally just did not have time to read through everything today. So, guys, as I said at the start of the show, Anne supplied me with a whole heap of information, a good chunk of which I have not had the chance to already go through. So there will be a part 3 to this once I've had a chance to go through the information myself. Tomorrow is Lady Overlaw'd's scheduled stream with me. So once every fortnight, once a month or so, I have my wife on with me and we just discuss topics. So because that's already planned, I probably won't be doing this one tomorrow, maybe the day after. But once I've had a chance to go through all the information, I'm hoping to bring a slightly more analytical view to this as opposed to just reading stuff. So, but I'm really hoping that this gets refiled, frankly. So, wait, where is... That's not the one that I want. That was the board meeting. That's the police update. That's the footage. He was allegedly Okay, that's fine. So what I'm going to do, because it is now... Oh, jeez. And I don't think that the Baldwin stuff's going to start for another, 45 minutes, is it? So Stingy sent me some stuff. Here they're filing with the Supreme Court since the First Circuit's out of alignment with sister courts. Excellent. Well, that'll be something for us to keep an eye on. Where are we? What's that? Puppy uses Undertaker to get out of court. No, that's something else. What's this? If you wonder how Norfolk County's Mass State Police Unit became the petri dish for corruption, remember, a fish always rots from the head. Oh, it's an interview with Morrissey. Okay. Let's have a look at this. Just make sure that I haven't got my messages open.
Etc. If one was looking at...
And let's have a quick look at this. It's only like 20 seconds, but there's another video there he sent me. Thank you. Thank you very much for that, Stinge. Audio up.
Etc. if one was looking at for employment opportunities with the district attorney's office,
Well, the first,
what would they
the
do?
state police are separate, as you
Yes.
know. So that's the state police hiring process. Is a class going on right now.
Mhm.
You have to get some experience, and you apply to the district attorney's office if you're a state trooper. And then I pay great deference to the selections they make. At the end of the day, it's still my choice.
Et cetera. If
Okay, so that's Morrissey basically admitting that he's the one that chooses who winds up in the DA's office. Okay. And we've got
Juston's Root.
Got a video from Justin's sister making a statement. Hang on.
My family and I.
Which again is nice and loud in my ear, so let's just double check that.
My family and I remain sickened by my brother Juston's Root's egregious killing
come
and the
on.
continued absence of anyone in a position of authority willing to enact a warranted independent. My family and I remain sickened by my brother Juston's Root's egregious killing and the continued absence of anyone in a position of authority willing to enact a warranted independent investigation. As long as law enforcement is investigating themselves, their colleagues, and have a close working relationship with district attorneys, we will not get to accountability. This is all we are asking for. The Norfolk DA's office used Boston police detectives and Mass state troopers to investigate their own colleagues, and in just 30 days, they called their investigation. They concluded that 31 bullets at Juston while he was on the ground bleeding with nothing in his hands, they concluded that was reasonable. Most of those 6 officers that shot him met as a group before they were even interviewed 5 days after.
And we saw the same thing in the Reed case. That is absolutely inappropriate. There should have already been things put in place to specify that, no, they're not supposed to get together. They're not supposed to get their story straight. And it was already disgusting seeing the video of after the shooting itself with the whole, did you shoot? Yeah, you shot. Yeah, great. Yeah, I killed that MFR. All that sort of. That was disgusting. I wholeheartedly agree with her on this, that frankly, as far as I'm concerned, if there's a police shooting and there's that many people involved, they should probably be putting them on paid administrative leave and keeping them effectively, I don't want to say locked down, but they shouldn't be in a position where they can get their stories straight, shall we say. So put them on desk duty, put them on whatever else, and make sure that they can't fraternize, I think is the phrasing I'm looking forward to.
There couldn't be a clearer conflict of interest. Given your experience, I remain hopeful that you will stand up for people like Juston, for the people who are voiceless.
Sequestered, thank you.
My question to you is twofold. How do you see your office addressing when officers use deadly force in this not so transparent process that is occurring in those investigations? And then also, obviously, I'd like to meet with you.
There's a lot the office
That's
can
one way
do.
to put it.
I want to first talk about posts, right? We have the Post Commission, which really, if resourced right, and I have some briefings coming up with them about how the AG's office needs to work with Post to look at cases of involving individual officers. So cases where there's an individual officer involved and folks have concerns, Post really is the right place. We could get referrals from them. And so the question is how in the office we make sure that we have adequate resources and attorneys for those types of referrals. So we're working on that. Individual cases, Post, AG's office working partnership. The police accountability unit that I proposed that we are working on setting up with this gun enforcement unit, 2 separate units, but they go hand in hand, is to address those systemic cases. The recent changes in some of our laws here in Massachusetts around police reform gave the AG's office incredible authority to look at pattern and practice investigation, so that's systemic stuff in a very meaningful way. This is the time to actually be more intentional of those types of matters.
That was just word salad. But, okay. Alright. If that's the way she wants to play it. I'm just having a quick look here. There we go. Looks like every man and his dog's dealing with Alec Baldwin today. So, I'll set the redirect for Vices, but I mean, he's not going live for another half hour. I mean, what can I really say about this? It's a case where an individual who was going through what was potentially a mental episode It was known to police who was, at the time that he was shot a number of times. I mean, don't get me wrong. Everything's hindsight. Everything's beautiful when you know, it's after the fact. Hindsight's 20/20. All talk, no action. Her brother died in custody and they never know what happened. No shit. Oh, God. Statement should be taken immediately. They normally give these guys a 24-hour cooldown before they give statements. So then why the hell wasn't that... Why did it take them 5 days then? That's another concern as well. But, all right. Anyway, guys, I got caught in the morning, so I'm going to have to go. He was at the hospital and should have been hospitalized amongst 4 mental health centers. It's honestly horrifying, to be perfectly honest. But all right, guys, I'm gonna leave it here. We'll pick up part 3 Friday morning. Yep, because tomorrow I'm in court. Thursday night got Lady Overlaw'd. Saturday we'll see what Saturday, Friday night no show. Saturday night my time. Saturday morning there will be a show. Sunday we've got the LFL stream, and we'll go from there. But as always, people, for the love of God, remember, you're not a piece of shit. You have value and you do contribute to society. And thank you to everyone that's hit that like and subscribe button. And as always, people, stay healthy, wealthy, and wise. And I'll catch you all on the flip side. Thank you so much to everyone that donated memberships and chats. And been there, done that. Your mum says sweet dreams. Well, sweet dreams are right back to it. Oh, wait. No, it's the middle of the day. It's morning for you guys. So, thank you. I'm sure I'll dream sweetly. Fuck this shit, guys. I'm out.
Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.
Okay. I'm just going to quickly mess around with the credits scene because that was annoying the hell out of me, and I just want to try and fix it. But I just want to be able to... I did the end scene so that I could just cut it and like not have that added to the thing. So congratulations, this is a live-only thing. So I want to open the dashboard and see exactly why that is not showing any super chats or anything like that. So let's have a look. No, custom website. What do I want? Widgets? All widgets. There we go. Alert box and credits. Okay, so what have I got it set for? I've got it set for... Yeah, well, I occasionally throw the Marvel treatment in. It's currently set to show subscribers, donations, raids from Twitch. So why is it not showing anything at all? Stars, credits, thanks for supporting the stream. I mean, if I just do subscribers, donations, moderators. See, because it wasn't even showing moderators either. So maybe if I just turn everything on, save it, and we'll give it a go. Show amounts disabled, roll credits on page load, yes. Custom HTML, is it turned off? That's all fine, that's all fine. Copy that specifically, and let's go back to the credits page and hope for the best. Oh well, doesn't matter. Maybe it'll set it up after I reset schedule for another stream tomorrow. But I'm just gonna have to hope for the best. Otherwise, I'll just have to add it as a. Oh, hang on. If I just add it as a browser source. Credits. Add source. Still not showing anything. Weird as hell. Don't know. All right. Anyway, I'll remove that and delete that because I don't need that showing again. Anyway, I'm out of here, peeps. Have a good day.